This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the duty to defend and the requirement for potentiality. In the leading case of Gray versus Zurich, a 1966 decision of the California Supreme Court, it set the basic rule followed in most jurisdictions for deciding whether an insurer owes a duty to defend or not. It found that insurers issuing dual promise policies, a promise to both defend and indemnify, are required to defend any suit in which there is a potentiality that the insurer will have to indemnify. The insured in Gray was alleged to have assaulted and battered the plaintiff. The policy and the statutes of California prohibited indemnity for an intentional act of an insured. Assault and battery are, by definition, intentional acts, so the insurer argued it owed no defense. The complaint against the insured only alleged the intentional tort of battery. The court concluded that the insurer should be compelled to defend, since there was a potential that the complaint could be amended, or the jury could find the insured's actions were merely negligent. The court's decision was founded in the wording of the policy, concluding that the duty to defend was broader than the duty to indemnify. The insurer's agreement to defend suits, even if they were false or fraudulent, caused the court to conclude that the insurer agreed to extend the duty to defend far beyond those acts for which coverage for indemnity might exist. The potentiality concept has expanded the exposure of insurers insuring personal and commercial risks. Even though a policy excludes liability arising from violations of law, there is the potentiality that the jury would find there was no violation of law and that the policy provided coverage. Of course, if there is no potential for coverage and hence no duty to defend under the terms of the insurance policy, there can be no action for breach of the implied covenant of good faith and fair dealing, since the covenant is based on the contractual relationship between the insured and the insurer. And if that contract was fulfilled, there was no breach and no right to a claim of breach of the covenant of good faith. Incompetent or inadequate claims personnel sometimes force insureds and claimants to lawyers. Prompt, effective, professional claims handling saves money for both the insured and the insurer and fulfills the promises made when the insurer sold the policy, as long as the claims personnel recognize that the duty to defend is based solely on the potential for coverage, no matter how extreme. Under Nevada law, for example, an insurer bears a duty to defend whenever there is a potential for liability under the policy. Once the duty to defend arises, this duty continues throughout the course of the litigation. The duty to defend arises only when there is a possibility or potential for coverage at the outset of the case. The duty to defend is determined by comparing the insurance policy language with facts. 1. Alleged in the suit. 2. The insurer knows at the outset of the case, or 3 that are reasonably apparent to the insurer at the outset of the case. If the complaint merely alleges facts that give rise to a claim potentially within the policy's coverage, the insurer has a duty to defend. Where the insurer has knowledge of facts which potentially bring the case within coverage of the policy, it has a duty to defend, even though the allegations of the complaint fail sufficiently to allege all of the facts requisite to do so. The Illinois Appellate Court held that allegations of recklessness in a claim for defamation did not amount to intentional conduct, negating a duty to defend. The court concluded there was a potential for coverage and that it need not address whether the duty to defend was triggered from the remainder of the counterclaims because the insurer's duty to defend arises even if only one of several theories is within the potential coverage of the policy. The court held, under principles of equitable contribution, that the insurer's other insurance provision required the other insurer to pay half the defense costs incurred by the insured and its executives. The court reasoned that the difference between the occurrence-based and claim-made policies related only to the trigger of coverage, and that the primary policies shared significant, fundamental commonalities of risk. In Executive Risk Indemnity versus Jones, a 2009 decision of the California Court of Appeal, it concluded that a policy that does not promise a defense need not pay for defense. But if the insurer chooses not to defend, it waives the right to appeal the outcome of the suit. The record confirmed that Executive Risk was repeatedly notified of the existence of the claim against its insured stars for negligent financial advice, an issue implicating Executive Risk's insurance coverage. Despite the entreaties of its insured, Executive Risk refused to intervene or otherwise protect its own interests in the ensuing arbitration and judicial proceedings, although it clearly had the opportunity to do so. Assuming Executive Risk made a calculated decision not to intervene or otherwise protect its interest in those proceedings, it was found to be not unfair to preclude Executive Risk from relitigating the court-approved judgment's determination of Star's liability and damages. The Ninth Circuit agreed, holding there was no potential for coverage, and stated, quote, "To support a finding of potential liability, the plaintiffs would need to allege new facts of bodily injury. Mere speculation that plaintiffs could or will allege such facts does not give rise to a duty to defend. The possibility of an amendment does not require the insurer to speculate about any conceivable claim that a plaintiff might bring against the insured or to spin out wild theories of recovery for every conceivable damage. Liability under the policies can only be characterized as speculative and hypothetical. The duty to defend, albeit a broad one, encompassing liability for damages potentially covered under the policies, does not stretch this far." Close quote. This is Upper Deck Company versus Federated Insurance Company, a 2004 decision of the Third Circuit. An insurer has no duty to defend a suit until the suit is filed alleging a covered cause of loss. A superior court ruled that, unlike in other states, in Pennsylvania, the insurer's obligation to defend is fixed solely by the allegations in the underlying complaint. It is not the actual details of the injury, but the nature of the claim which determines whether the insurer is required to defend. The duty to defend is limited to only those claims covered by the policy. The insurer is obligated to defend if the factual allegations of the complaint on its face comprehend an injury which is actually or potentially within the scope of the policy. This is Old Guard Insurance versus Sherman, a 2004 decision of a Pennsylvania appellate court. By so ruling, the Pennsylvania court took actual fact out of the decision-making process with regard to the duty to defend. And if the plaintiff artfully wrote the suit, it made the insurer defend so that the injury alleged is actually or potentially covered by the policy. The insureds purchased a policy with a business exclusion. The trial court and the Court of Appeal found that the exclusion precluded coverage for personal liability arising out of a business. In California, the duty to defend exists whenever an insurer ascertains facts which give rise to the potential of liability to indemnify, unlike the obligation to indemnify, which is only determined when the insured's underlying liability is established. The duty to defend must be assessed at the very outset of a case. An insurer may have a duty to defend even when it ultimately has no obligation to indemnify, either because no damages are awarded in the underlying action against the insured, or because the actual judgment is for damages not covered by the policy. The Supreme Court of California, in fact, found that the insurer and the insured are allowed to use extrinsic facts, facts outside the allegations of the suit, to determine whether coverage applies, and is different than other states that apply the so-called four corners or eight corners rule. This was decided in a case called Waller versus Truck Insurance Exchange, a 1995 decision of the California Supreme Court. In so doing, it circumvented the imagination of a competent drafter of a lawsuit and limited its decision-making to the facts, allowing coverage decisions to be made using extrinsic evidence. California stopped the insured from using careful drafting or the claimant suing the insured to prohibit the insured from receiving from its insurer a paid-for defense to which it was not entitled. This video was adapted from my book, Zelma on Insurance Claims, Part 103, the third part of the 10-part treatise, Zelma on Insurance Claims, which is available as a Kindle book and as a paperback from Amazon.com. If you found this video to be useful, please forward it to your colleagues. It's free. And please also subscribe to my Rumble channel, my YouTube channel, and my blog so that you can be advised of future blog postings and future videos. Thank you for your attention.